Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hey everyone, welcome into an all-new episode of the Business Law, Estate Planning, and Estates Podcast with attorney Thomas LaPorte. I am your host, Mike Leon. Thomas here is the founder of LaPorte Law Group, PLLC. They've got an office out in Portsmouth, New Hampshire, and a location out in Andover, Massachusetts. And they've got more than 30 years of experience helping individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. Today's episode, we're going to be talking about contracts, contract terms, clauses. Small businesses, owners, they often overlook these things, and why the details matter more than people think. Thomas, it's good to see you as always. So let me ask you real quick, when you're reviewing a client contract, right? And it's a small business. So what are the examples of the primary aspects of or sections that you start to analyze to obtain a sense of, whether the document is truly strong for the client or it's going to need some work?
It's a good question, Michael, and thank you for asking it. The smaller the business, the less leverage it's going to have. So the small business owner that's just starting out is anxious to get that first contract, is willing to take more risks. So my job is to review the contract or the proposed contract, push back, if you will, as much as I can without losing the deal. So that's the art of being a good contract attorney. As the the business grows and matures, it may obtain more leverage. And at that point, more risks, more pushback of risks can be moved across the table to the business partner. So those terms include, first and foremost, guarantee of payment, when payment's going to be made, making sure there's no contingencies upon payment. If it's an international contract, currency, dispute resolution. We want to make sure that is in favor of my client, if possible, so that it chooses the state where it's headquartered, the choice of law that's going to be applied. Also, we would like that to be his or her state or their state, if possible. There are other dispute resolution clauses that I would review. If there's a termination of the contract, we want to know, first of all, the time and the length of the contract, what the termination provisions are. We don't want to order 50 widgets to service this contract, and all of a sudden this contract's terminated. We're stuck with 40 widgets. I've seen that happen. We want to make sure that any steps taken, concrete steps taken to fulfill those contracts is going to be paid for by the business partner. That needs to be put in the details, as you mentioned. Details. The devil's in the details. I look for the devils that, if you will, that support the opposing, but we want that to be a business partner, and try to create devils in details that are in favor of my client.
You just mentioned payment terms. So let me dive into this, because sometimes payment terms can appear a little bit simple on the surface, but what are some of those devil in the details within those sections, whether it be timing, conditions, added fees that tend to be the most important for the business owner to understand?
Sure. You want to make sure that the time of payment is certain. 30 days. Well, make it calendar days, not business days. There are provisions regarding lengths of time that say 90 consecutive days. No, that where they could say suspend the contract. No, it's not 90 consecutive days. It's you want to be 90 consecutive as opposed to 90 full days. Okay, in some instances, meaning a total of 90. We want to determine how payment's going to be made. Are you going to require a wire transfer into what account? Or cashier's check, or other arrangements. Once you get to know the business partner better, perhaps checks from their businesses are more reliable. There's indemnification clauses. There's insurance clauses. Indemnification means that if there are claims by third parties from your business partner arising from their clients related to the service or product you provide to them, well, you want to try and limit your exposure to any available insurance coverage you may have, or limit it to the cost or the purchase price that your business partner paid. Otherwise, it could be unlimited, for instance. So that's both payment as well as defensive indemnity. And one other thing that is related, you never want to agree to defend somebody. If there's a dispute, then defend means you are paying their attorney's fees. And they get to choose the attorney, and the attorney gets to choose its rate. And some of these attorneys in some of the largest cities, $600, $800, $1,000 an hour, and you've agreed to it.
Thomas, in a previous episode, we talked about, a company that's located in X state but has employees in another state. Now, when two parties are working together across New Hampshire, Massachusetts, or whether it be, let's say, New Hampshire and Maine, how important is it to confirm which state's laws apply in those situations and where any dispute would be handled?
Well, it's very important. Let's just take New Hampshire and Massachusetts, for instance. If Massachusetts laws apply, then it's more expensive to resolve a dispute in Boston than it is in Concord, New Hampshire, both travel wise, expense wise, and the cost of the mediator or arbitrator, if it is subject to a mediation or arbitration clause. And just if it's an extended dispute resolution at trial, well, that could entail experts that come from those urban areas and lodging, expenses, parking, and those types of things. So aside from expenses, you'll want to try and get your headquartered state's laws to apply, at least to some of the non-employee, if there are employees involved, issues. Any company that's doing business in another state that involves its own employees in another state is going to be subject to that state's laws protecting their resident employees.
Let me ask you about contracts, because some of these contracts that I've seen have automatic renewals or they've got these long notice periods, right? So what are some challenges that those create for a business that's looking for the flexibility, as especially not only as the business grows, but the relationship grows, or it could change?
Well, you mentioned yourself, and the key word is flexibility. A long notice clause, or which it's easy to miss. So if one wants to terminate the contract for whatever reason, it's a bad bargain. One feels that they can negotiate better terms with your business partner or sell their goods or services to another business partner, then you don't want to be locked in for, say, 6 months, which would be an example of a long notice clause. And a notice clause means that a business has to affirmatively opt out, saying, I'm not going to renew this contract 6 months from now. It's easy to miss those deadlines. So automatic renewals, unless it's in favor of you, are something to be wary of. In general, as a business matures, laws change, you want to be flexible, and it allows you to be more strategic and nimble. So the shorter the time period is that will allow you out of a contract, whether it's good or bad, is going to provide you that flexibility that is important to any company.
Thomas, without giving any specific examples, can you share from your experience, like where a business thought a contract looked straightforward to them, and then a small issue maybe or some type of clause ended up causing an issue down the road?
I can, yes. It involved a secondary market hardware provider back in the day before the Best Buy stores and whatnot, but it's applicable today. There are devils in the details with commercial leases, triple net leases, which means that you pay insurance, you pay common area maintenance charges, you pay the taxes that are applicable to your unit in the building where you're located. All of those are additional rent in addition to base rent. It can more than double your rent. In addition, in addition to indemnity, and who's responsible for maintenance of things like pipes in the wall. How does a tenant get into the wall to fix pipes, air conditioning units, capital items? Those ought to be borne by the landlord. But the one in particular that comes to mind was a catastrophe clause. A catastrophe clause means that where there's a fire or a flood or some business interruption that interrupts the tenant's, in this case, my client was a tenant, business, then they get to pay a reduced amount of rent or bate their rent, meaning not pay rent, while their business is interrupted because of these catastrophes. This particular clause, I recall, was so one sided and unfair and unrealistic that my client, if it experienced a business interruption, I usually define that too by a reduction in gross revenues by 25% or more. So I try to make it as low as possible because a 25% fall off in revenues can be the difference between operating and not operating. It doesn't have to be a full catastrophe, bankrupt, not meeting your bills as they come in situation. It needs to be a significant impact on your business. Well, this clause, as it was drafted, was so onerous that had it not been changed, and we did change it, my client would have incurred $280,000 extra in rent, even if they were making no revenues or income.
Wow, that's a huge difference.
It was pretty big for this size company. Yeah.
So, Thomas, we talked about in a previous episode, like W-2 employees versus seasonal and contract employees. When a business is hiring contractors solely instead of having regular employees, what kind of contract terms help make that relationship really clear and important and compliant? Excuse me.
Well, contract terms, and the states are not going to be convinced simply by what a contract says. However, one should track the language of the state statutory employee law, and they're all different. Some of the ones are less stringent, meaning what is the extent of control of the master of the servant and the master-servant relationship, and that would include employer, employee, or contractor, independent contractor control. And then beyond the contract, you want to make sure that the contractor certifies to you that he, she is providing his own general liability insurance, own workers' compensation insurance paid to the state, can make his own schedule, controls the hours that he or she or it utilizes to carry out the service that you contracted with, is control of its own vehicles, tools, and implements. And that really has to be the real case, and then memorialized in the contract as such to create that distinction. It's become very much more difficult for employers to escape what has become really the statutory employee doctrine, but it still can be done. But the contracts have to reflect the actuality of what is happening in that relationship. So if you have that party certified to you, then you can at least argue, look, I did everything reasonably possible to determine and make sure that this contractor, this person in Oregon, and I'm in New Hampshire, was an independent contractor, controlled its implements, controlled its time, worked for other companies besides my own, for instance.
Thomas, as we wrap on today's episode, for people that are listening right now, maybe they haven't reviewed their contracts in a while, can you provide them some examples of what steps can kind of help them make sure that their various agreements match how their business is operating today?
Sure. Well, you ought to look at your contracts for a variety of reasons. Non-compete clauses have become more strictly construed. You may want to have those revised. You can strengthen your non-solicitation, non-use clauses. Those will be enforced. Data privacy has become a big issue. In Massachusetts, it's the Data Privacy Act, but it's been the other 49 states have modeled their statutes after Massachusetts. That is important, specifically when you're dealing with third parties, clients' information. It's much like HIPAA with regard to patients. Your company may have matured, so you may want to adjust payment terms so that you're paid more frequently. The late fees are a little bit higher to encourage prompt payment. You then have a little bit more leverage to push back against indemnification clause. You may want to limit what you will indemnify the other party against when third parties make claims. You may be able to get rid of some clauses that you had to accept in the beginning of the relationship. Those are some of the things that come to mind, and there are others.
Thomas, thank you as always for the time, insights, and all the analysis on this. Truly appreciate it.
You're welcome, Michael. Thank you.
And thank you for everyone listening to this installment of the Business Law, Estate Planning, and Estates podcast. If you want to learn a little bit more about what Thomas and the team do over at LaPorte Law Group, do me a favor right now, visit laportelawgroup.net. You can connect with Thomas and the team there. Don't forget to like, subscribe, leave a review, and comment or share the episode with someone who needs to hear it. I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.